morning, everyone. I'm Amna Al-Uwais, the Chief Registrar at the DIFC Courts. Thank you for joining us in our inaugural episode of the Beyond the Scope virtual event series. Today's topic is arbitration and mediation, a new way forward or lost potential for global courts. Within the series, we at the DIFC Courts hope to inspect matters beyond the scope of the courts. We aim to leave each episode with a better perspective and a renewed vision of the future of the legal field. We have invited legal experts to share their thoughts and discuss with us if arbitration and mediation are really the way forward in dispute resolution, and to investigate the opportunities, if any, for a court system to complement and assist these dispute resolution channels. I am honored to have our esteemed speakers with us today. Please allow me to introduce them. Michael Black, QC, is a senior figure in the Dubai legal market. He is one of the leading arbitration specialists for the Middle East region, both as counsel and arbitrator. He is also ranked as a global market leader in international arbitration. Michael was the first barrister to be given rights of audience before the DIFC courts and appeared in both the first trial and the first appeal. Robert Loosely is a senior legal counsel at Standard Chartered Bank and is the regional head for disputes and government investigations. He has practiced as a barrister in London before moving to Dubai in 2009. He spent 7 years in the arbitration team at Al-Tamimi & Co., handling complex commercial disputes, and appeared regularly before the DIFC courts and arbitral tribunals as an advocate. Victor Liginsky is a chartered arbitrator, certified mediator, and independent international arbitrator. He has been tutoring, assessing, and assisting candidates to achieve success in arbitration seminars for well over a decade in the Middle East. Victor holds a Juris Doctor degree and a Bachelor of Education, both from Canada. He has served as an arbitrator in well over 100 cases, conducting both institutional and ad hoc arbitrations. So with that, let me start our first question to get the discussion going. And this question is open to all of our panelists. And the first question would be, what would you choose based on your experience as barrister or in-house counsel or lecturer, advocate, and so forth, in terms of dispute resolution? Please, Michael, if you can start.
Yes, well, I think the answer to that depends on the nature of the dispute, really. I was fortunate enough, well, a long time ago now, perhaps nearly 30 years ago, to study alternative dispute resolution at Harvard Law School under the legendary Professor Frank Sander, who actually invented the whole concept in the 1970s. And he had the idea of what he called the multi-door courthouse, where you have a single point of entry into the court system, but then different disputes are guided into different channels depending upon the nature of the dispute. And the court system is able to accommodate the needs of the parties in each individual case. He summed it up nicely, really, with the phrase to fit the forum to the fuss is the way he put it to his students. And so, as I say, it depends on the nature of the dispute, really.
Robert?
Yeah, thanks, Amna. Yeah, as a bank, we have operations across 70 countries. You do an awful lot of work in various different types of banking. So we come across a whole variety of different types of disputes, small and large, cross-jurisdictional, very local. So we explore the full range of possible dispute resolution mechanisms. I would say by far the most that we use are local courts, because that tracks with the kind of local disputes that we have in the franchises across the globe. But absolutely, for more complex transjurisdictional transactions, we would be using arbitration. Obviously, we try and negotiate settlements anyway, if we can. But where we have to go, that's where we are comfortable. And absolutely with mediation, which I'm sure we'll touch on a bit later, we're very pro mediation. We don't see too many of them, but as an arbitration is what we use for the very complicated and high value disputes. So they tend to be a bit rarer. These are matters that we would tend to try and settle off. But no, the full range, and we see across the network that we have in different jurisdictions, the different approaches, whether it be West African approaches and East African, and obviously in the Middle East, and is tremendously varied. And you can't assume that what fits in one jurisdiction is going to necessarily appeal to the market in another.
Excellent. Victor, we'd like to hear from you. Victor, I think there might be an issue with your head mic or presence. Like we can't see you on the camera.
Hi, Amna. Victor is facing some technical difficulties. He's joining in a minute here.
Okay, no worries. So let's continue the discussion, Michael and Robert. In terms of, as you just mentioned, again, it depends on the case involved, depending, of course, from day one when you draft the contract within the dispute resolution clause. That is really when you decide which would be the best forum, depending on the nature of the actual transaction, depending on the jurisdiction, when enforcement takes place, where would you need to go for enforcement. So I think, as you mentioned, these are all let's say, foundations that help you decide which would be the best forum. I heard the stereotype that, they mentioned that lawyers normally prefer to avoid mediation, lawyers who are in private practice specifically. Do you agree with that, Michael?
No, I don't. I think there are certainly some cultural issues, and it's very interesting what Robert says, because he has the experience of operating across different markets, and also, of course, a bank litigates in a particular way. I mean, a bank is generally a party that wants to recover money, but there are other natures of disputes. There are other natures of disputes about the relationship between parties and ongoing relationships. Very typically, for example, the employment relationship, but there are also consumer relationships as well. And the court, of course, will deal with all of those different relationships. And so the good lawyer is going to look at what is his client's best interests, and so it may well be in a client's best interest to litigate and just recover a sum of money if he's just a creditor, or if that entity is just a creditor. But on the other hand, if there is the preservation of a long-term relationship, a long-term trading relationship, then mediation may be much more useful than a simple one-off decision of the courts. And that's why courts have to come back where I started, offer the different the different avenues for dispute resolution, I think.
And if I could just add that, the bank is very much pro mediation, and my experience has been positive. And I think generally that the experience of the bank is positive, that when you go through a formal mediation, it either settles during that process or in the weeks that follow it, that it's usually, again, even if you don't fully settle it, you've had other benefits out of it. Having said that, we're not doing mediations every other week. We don't put mediation clauses in our agreements, more or less. And that's, again, nothing to do with the fact that mediation is not effective. It's to do with issues of, if you have it in the agreement, you might have to go through with mediation in circumstances where it's not ideal, or you doubt that the other party is really that keen on it, and it could just be a delay to getting on to the formal litigation or arbitration process. And there are costs involved. I mean, you said this thing about, our external counsel pro mediation, or are they hesitant about it? My experience has been they don't tend to raise it. That's true. But I don't think it's because they don't like mediation. I think because mediation can be a bit of a hard sell when you've already spent time negotiating, you're getting close to having to pull the trigger on a formal resolution process. And then you say, well, how about mediation? There are some additional costs. There are additional papers that have to be presented on that, and you could spend 2 or 3 days and not get a final resolution to it. Quite often, the business will say, well, that in itself creates high risk. It's high reward. Obviously, you could settle way before the very vast expense of an arbitration, but there is risk there. So for us, we don't put it in the contracts. We wait to see how things develop. If we feel there is an opportunity for a mediation that could be successful, I think it's usually the bank that actually promotes it. to external counsel, we're normally saying, well, why do we consider that? Do you think it's a good idea for mediation? And our experience has been that external counsel are usually very happy to do that. But I think they're hesitant to be gung-ho about it because of those additional risks that it brings.
And Robert, on that note, with the presence of the new Singapore Convention on Mediation, and of course, I know that that still has not been implemented in many jurisdictions, and there are signatories to join that convention. But with that in mind, with you just mentioning, the time spent in negotiations and then mediation and then ending up in courts, maybe having something such as the Singapore Convention mediation, which actually effectively makes the mediation settlement agreements enforceable, similar to arbitration and court judgments. With that in mind, would you be keen on more, getting, to expose yourself and choosing mediation as an alternative dispute option to resolve the disputes?
I think the answer is yes. I mean, we've been following the developments in Singapore very closely in relation to that convention. And as you said, it hasn't had a massive amount of take up, and it may be that there's a tipping point to come where more and more countries sign up to it, especially in our network, in our footprint, and then we feel actually this is a really helpful thing that we should be pushing for more often. I mean, my own view is I think it's a very interesting concept. It's obviously very helpful. Anything that helps get to a better enforcement is going to result in more efficient dispute resolution mechanisms for the benefit of business generally. I think one issue that I've had with it is I don't really understand how, if you just negotiate a settlement, that is just a contract, whereas if you go through the hoops of that Singapore Convention, you turn up with this very special settlement agreement. Because obviously mediation is a form of structured settlement, but that convention gives it a special status. And I just wonder whether we're going to find people basically negotiating and then trying to force it into there in the way that you might try and convert an arbitral award into a judgment or something like that. But it's great. I mean, from the bank's perspective, the more choice, the better. Like I said, we have a huge variety of matters, and it's not one size fits all by any means. So having these type of opportunities arising is great. And you're seeing these developments all the time. I think just last week, I was reading about Bahrain, and they've come out with a new set of procedural tweaks to their rules saying that you could potentially go to court in English in Bahrain, and it's an exciting region where we are because these developments are coming out all the time, let alone across other parts of the world. And absolutely, we're monitoring them, and if we can get used to them, we will do. But I think, as a bank, we are always slightly cautious. We may have to see how others react and see how effective it really is.
Yes. Thank you so much, Robert, for your insights. Michael, that brings me to, on a similar note, in terms of conventions, based on your vast experience in arbitration, the New York Convention has been there for many, many years. Since its inception to date, how do you think the New York Convention has helped and maybe evolved in terms of helping arbitration, judgments and, recognition of awards? Since that experience can help us imagine how the Singapore Convention on Mediation will help in maybe 10 or 15 years to come.
Well, I think that the reality of the situation is that international commercial arbitration, and we leave aside investor state because it's a whole separate structure for in terms of convention. But in terms of international commercial arbitration would not probably exist in the form it did, but for the New York Convention, because the New York Convention obviously facilitates the enforcement of an arbitral award in upwards now of, I can't remember the last figure, 161, 162 countries. It's difficult to keep up with it. But compared to a court judgment, the enforceability of an arbitral award is so much easier. And consequently, that's why I think international business favors arbitration, because of the international enforcement. So without the New York Convention, I don't actually think there would be international arbitration in the form that we know it at all. So if ultimately, as you suggest, mediated agreements become equally enforceable as arbitral awards, then I can see clearly that's going to aid the development of mediation as an international form of dispute resolution. I mean, there are other advantages to mediation, obviously, over international arbitration and litigation in terms of speed and costs and the preservation, as I said before, of relationships. But ultimately, if parties know that their brokered and negotiated agreement has international treaty recognition, I think that will aid things enormously.
Michael, you just said that, for example, with the New York Convention, it enables channels of enforcement internationally, and that's what is really key, enforcing the awards or turning, as we know, judgments into money. So with that said, don't you feel that court systems, or let's say judgments out of courts, are not as enforceable as New York Convention awards?
Not yet. We obviously hope that there will be wide recognition of the Hague Convention, which will equate court judgments to arbitral awards in terms of enforceability internationally. But you still have the problem in some jurisdictions that courts will not enforce the judgment of another court in another jurisdiction unless there is a specific bilateral convention rather than a multilateral convention like the New York Convention, which covers effectively the whole world. So you're still relying on individual conventions, and they differ in their terms. We've seen some of those issues in the DIFC court itself with recent decisions on the Riyadh and GCC conventions in terms of the enforcement of judgments. So it's a more complicated business to enforce an award, a judgment, than it is an arbitral award.
Is that, Robert, an experience that you share with Michael, that court judgments are much more difficult to enforce rather than arbitration awards?
Yeah, I think that's right. I think from my experience, working in the bank, it's certainly a factor that we consider enforceability when we're looking into which form are we going to use. You're negotiating, so each party will have certain clout, and you may not get the choice that you wanted, but that's absolutely front and center. There's no, as you said, no point getting a judgment in one country which is not going to be enforceable in the country where the assets are. Likewise with arbitration, if you know that a certain jurisdiction doesn't like, even if they should like it, but they don't like to enforce arbitral awards for whatever reason, and there are countries out there which have better than other reputations on that front, then that's a factor. I mean, it has to be, as you said. I mean, most disputes, as I think we know, don't ever get that far, and if they do, will settle on the basis of the arbitration award anyway. So most parties don't want to have to go through an enforcement process. But when you do have an awful lot of risk on the table, the parties don't have that money to pay out or otherwise feel protected in their home state, then yes, all the tricks will come out of the box, and you'll be fighting for that enforcement. I mean, I would say from the bank's perspective, we're in a fortunate position because we normally have time on our side. We're not going anywhere. If we have to see it through, we'll see it through, and that happens. We have cases going on for many years. But it's one of the risk factors that we have to assess on a case-by-case basis, and yeah, we have to do your best. But all you're talking about is managing risk. No one knows what's going to be happening on any enforcement process, or what's going to be happening in a couple of years' time. So it's just managing the risk as best we can, playing the odds, and then hoping for the best.
And in terms of court systems, do you believe in terms of having arbitrations as, being successful, including enforcement of awards? What do you think is needed from court systems, what are the ingredients for any court system to actually become a friendly court to arbitration? Because again, it's a relationship that needs to happen. You can't enforce judgments without, at least awards without court systems in place. So from your experience, what would be a successful model in terms of ensuring awards are ratified in the right way and enforced, in the best possible manner, Robert?
Sure. I mean, I don't know that I have any easy answers. It seems to me the sort of root cause for the differences is you've got your court system, which is founded in the sovereign rights of that state and is enforcing their view on the merits of a particular case. And then you've got arbitration, which is, well, the parties have agreed to it, so whatever happens, that's their fault if they're not happy with it. And we're happy to then enforce the award that arises from it. And if you say to the court system, well, why don't you be a bit more like arbitration, maybe give some of the power back to the parties, or be a bit less concerned about certain procedural matters, just broadly saying that courts have to be a bit more procedurally heavy than arbitration. The problem will be that you'll fall back to the sort of litigation process that you kind of had in the English system, before the changes in the 90s and so on, where parties were allowed just to get on with it, and it just took many months more, years more, because the courts weren't so interventionist. So it's a difficult balance. I think the core priorities have to be efficiency, both in terms of time and cost. And the courts have a fantastic advantage over arbitration because, broadly speaking, they can give orders for strikeout, for doing away with ridiculous claims and defences, which in arbitrations are getting there, but are still not quite there for various factors. And so I don't think you'd want to sort of throw the baby out of the bathwater. I think the two different mechanisms have very different strengths and weaknesses, and it's for the parties to understand those and choose the ones they want. I mean, if it's possible to have more variety in the way that the courts approach certain cases, that's great. And as you know, the DIT courts, as with other courts, it's small claims tribunal, and you have different processes. And we know in the English system, they're looking at disclosure in different ways, different types of severity of disclosure, to try and do away with costly exercises which really don't fit that particular dispute. But the downside to that is more complexity, right? Because you've got more routes to choose from. So it is a balance. And I think it's one that the parties just have to educate themselves on, and then choose the right one that hopefully fits the disputes that might arise in the future.
Your microphone is muted.
Sorry. So Victor, I see that you're with us on the call now. Welcome to the chat. Victor, I'm really, you're on mute as well. We always forget to switch it on and then off and so forth. Victor, welcome again. I'm really keen to understand. I posed the question to Michael and Robert in the beginning regarding their own, let's say, preferences as practitioners. What would you say, like, as far as you're concerned, what would be your preferred dispute resolution process that you would go for, and why? You're still muted, Victor. Still muted. Victor, perhaps try to press once, and then we'll see. Maybe sometimes it takes a longer time. That's why you need to wait before you press again. So can you try to unmute now? You're still muted. So Victor, maybe you can type your answer, at least. Like, I'm really keen to understand exactly, as far as your experience goes, what would be your preferred model in terms of dispute resolution? And then we try to fix your speaker or mics in the meantime while we continue the discussion with Michael and Robert. We're still muted. So Michael, you have vast experience within, the Middle East, and you've been able to experience different models, especially the new commercial courts trends, I would say. What do you think is the key in making sure that the court is actually successful as far as dispute resolution is concerned? You mentioned the concept while you were in university, and how do you think that that can be applied to commercial courts in terms of the concept of the multi-door courthouse? How do you think that can be translated into commercial courts, at least in the ongoing era of commercial courts worldwide?
Well, first of all, there is no dispute, I think, that can't be mediated, from the very, very largest of all disputes to the smallest. And as I was saying before, the court needs to accommodate the needs of the parties and the nature of the dispute. And it's a matter really of different tracts within the court system. So I think, for example, the DIFC court has been very, very successful with smaller claims. When you get the SCT, the small claims track. Just a little bit of history, of course. I was involved in drafting the rules of court. When we drafted the rules of court, the main rules of court, ADR wasn't so prevalent, so Part 27 of the RDC is based upon the English rules at the time, which gave guidance, but they didn't move people in a particular direction. But the SCT was a later development, and that has within it the mandatory phase of consultation, which is effectively an ADR provision. And of course, it's dealing with smaller claims, but they're claims where there is that relationship that we've referred to before, largely employment claims, but also smaller commercial claims and consumer claims. And that has been enormously successful in terms of mediating or conciliating disputes at the consultation phase. As I understand it, something of the order of 75% of all claims are settled at that stage, and then up to 100% in certain years go on to settle thereafter. And so, I think that the DIFC court's been very successful in the small claims track in doing precisely what I said before, in guiding appropriate claims towards a mediated settlement. We can discuss perhaps the larger claims in a moment in the context of what can be done and what further developments can be made in relation to that.
Hi, can you hear me now?
Yes, we can.
Oh, great. Okay. Sorry, very sorry about the technical problems. I was on the phone to your IT, and I think we finally have it sorted out. So thank you very much. So I'll be happy to pick up where you wish. So
I don't think we can hear Amna, but we can hear you.
Amna's on mute.
Sorry. I apologize for our audience. Anyways, we're keeping it fun. I think you're all enjoying, the never-ending stories with virtual experiences. So I'm on now. I'll keep it on. So Victor, I asked you the question regarding your own experience. What would you choose in terms of dispute resolution? What would be your preferred model and why?
Well, it's interesting. One experience I can share with you is with the Asian Infrastructure Investment Bank. I went to some meetings a couple of years ago because they were trying to solve that very problem. With the Belt Road Initiative, what dispute resolution is best? And I think that's really what we're looking at here, is what dispute resolution is best. And so we went through standing courts, we went through arbitration, we went through some sort of combination of courts and arbitration, regular courts. I mean, there's many options. The only thing we could decide upon, which is picking up on Michael's point just now with the small claims, is robust mediation. Robust mediation is a good way to begin, and that should be part of, like a formal mediation process should be part of any dispute resolution technique. After that, it seems to me in the international sphere, and you may think I'm saying this just because I'm an arbitrator, but I do think arbitration still has quite a few advantages over what we call international commercial courts in the large international sense, and that's largely because of the enforcement. If you have truly international parties in the dispute, then the enforcement, as you know, under the New York Convention is much more seamless than it is under, any kind of court provision. I mean, there are some movements to try and get courts to have enforcement provisions. There's the Hague Convention, or the Hague Conference on Private International Law, which has the 2019 recognition and enforcement on foreign judgments in civil or commercial matters. It's an international treaty, but so far it's only been picked up by 4 or 5 countries. You have the Commonwealth model, where you have reciprocal enforcement acts, but again, that's largely amongst Commonwealth countries. Then you've got the Standing International Forum on Commercial Courts, which has a multilateral memorandum on the current best means of enforcement of commercial judgments between members. Again, you fall back on a patchwork of treaties and conventions. In this region, we have the Riyadh Arab Convention, the Gulf Cooperation Council Convention. But at the end of the day, there isn't an overall way of enforcing judgments. Now, as Michael said earlier, I think it was Michael who said it, that they're working on it. I mean, through the Hague system, they're trying to get a convention that will rival that of the Newark Convention for Arbitrations, but currently it's just not there. So it goes back to what Robert and Michael have said. It depends a bit on who's involved and what the dispute is. But if you have truly international parties, it's difficult to beat the New York Convention for enforcement.
But let me be the devil's advocate pro courts. What if a court system is, in a civil law country and has, the best of both worlds, really? Common law, reciprocal enforcement of judgment, which happens normally between 2 common law courts. Most probably they will always honor the judgments of each other's court. And then being within a civil law country, part of those treaties as well, such as the Riyadh Convention, GCC. Do you think that actually, gives that extra plus or attractiveness for courts that belong within such jurisdictions?
Oh, definitely. If you have the ability to enforce in Commonwealth countries, plus being a court, you have more powers than an arbitration tribunal has. You have injunctive capacity, you have the capacity for service, and perhaps to bind third parties to, at least you have more ability to bind third parties than an arbitration tribunal does. So yeah, if you can beat the enforcement issue, then certainly a court is better, and especially one that's flexible, like DAFC, like ADGM, like some of the courts that have the ability for the parties to choose certain things, to choose certain procedural aspects of their court case. That's the best of all worlds, I think. It's just the enforcement piece that we're not quite there yet, I think, on.
And in terms of court, let's say internal initiatives, what would you say? I believe what I'm hearing now is like court systems who belong from such unique jurisdictions can be competitors to arbitration. In order to become even more, let's say, attractive and more of, the best choice for businesses and, people within a specific transaction or commercial contract, what would be, let's say, in an ideal world, what would courts belonging to such systems need to have in order to make sure that they're the best forum of choice?
Well,
and this is open to all. After Victor, Michael, and Robert can answer as well.
Well, I'm actually going to shift over to Robert, I think, because what international commercial courts have to do is follow what business requires. I mean, obviously, what we do in the international commercial court system is we assist businesses in resolving their disputes efficiently and effectively, as most cost effective as we can. And so modern business has certain different attributes than in the past. So we have to really listen to what business needs, where it's moving, what it's getting, where it's going to. Will online dispute resolution, for example, for smaller cases be something we should be moving to? So I think we need to shift to the Roberts of the world to tell us where business is going. Where is business going? What do they need?
Sure. I mean, I'm aware that, for example, in certain markets like in India, online arbitration is booming for certain sector of disputes, obviously the more consumer side of things. I'm not sure it's going to immediately find its way into the more substantial disputes that we deal with. I think, one thing that we look for is consistency, and I think the more consistent the courts can be in the way that they manage matters, the more experienced the judges are, that's a huge advantage that they can have over arbitration, for example. I think one of the other major advantages of courts, which we haven't touched upon yet, is they do make the law, and that can be a huge advantage. It can be a disadvantage if it goes the wrong way, but I mean, it can be a hugely powerful tool, obviously, for banks or other players that have real interests in seeing the law develop in ways which are beneficial to the community. And Michael and I have worked on a number of cases over the years when I was in private practice, and one that we dealt with that was in arbitration was all to do with set off. And I remember it was quite colourful in a way, because all the cases were going back to the 19th century or before that, about cigar boxes and all this. And I remember researching saying, is this really the state of the law on these issues? We're going back to 3 or 4 page judgments from courts that have long been superseded, and that was the case. That's what we had to argue about. And the award came out. We had a very high-powered tribunal, and it's a shame. It's a shame that we had all of this expertise ploughed into these issues, and no one else could see it, and it didn't develop the law in any way. And there are ways that you can try and get it into the courts in certain aspects, and force it through. But I mean, it is a danger to both the courts and the general development of the law if you're seeing large, important issues being dealt with in a private way. And that's something that I'm not saying as a bank we will deliberately put things into court to get certain judgments through. Obviously, we have to do what's best in all the circumstances. But I'm well aware of situations where we've appealed certain judgments, not because of the commercials are there, just because it was not a good judgment, or we didn't feel it dealt with an important commercial issue which was of interest to the community, and we needed to get that resolved. And the instance that I'm thinking of, which was in one of the GCC countries, that's exactly what happened. We got a good appeal judgment, and then we left it there, thanks, and that was helpful. So there are real benefits to using the courts. You've mentioned some of them. It really does depend on the circumstances, and as I was indicating before, I don't think I would want to see a sudden revision of how courts work or how they operate, because those benefits are really very strong there. So to my mind, you want to have a healthy competition and a healthy mix. And I think people would say that the way that arbitration has developed, they've really worked hard to get into the systems, procedures such as strikeout and so on, to make it more efficient. And that's great to see also. So for me as a consumer of dispute resolution mechanisms, these are good times. And we spoke about international courts. We have a huge presence in Singapore, right? Singapore's got a huge international commercial court there. We've dealt with matters there. We've had a fine experience there. It's not a real issue for that. Does it mean that we're going to plow all our disputes into that one forum? No, for a variety of reasons. But as we get more familiar with them, then absolutely, we will start considering, whether we push harder to use them, because we have confidence. A lot of these changes take time to bed in, and it takes some years, not only for the disputes to arise, but just for enough confidence there to say, yes, we'll go with that. And when you're looking for confidence, you want to see consistency, you want to see quality of judgments, you want to see enforceability. And that's something that we're always keeping an eye on.
I think courts have 2 very distinct advantages over non-state dispute resolution procedures. First of all, you're always going to have to come back to a court to enforce your award or your settlement brokered in mediation. Plus, there is an advantage that a court system with multiple judges has over an arbitral tribunal. An arbitral tribunal is 1, 3, or possibly 5, I've seen, individuals, but they act within a mandate. And a constrained mandate. It's always been a debate within the arbitral community whether arbitrators can act as mediators and then go back to acting as arbitrators, or whether once they act as mediators, that's the end of their mandate as arbitrators, because they will have heard privileged communications and understood the position of the parties. Whereas a court with a large bench a judge can say, we can take this issue and you should go away and either go away to a neutral or even to another judge, to a settlement judge, and try and settle this case, and then come back to me if you can't settle it. And that's a huge advantage that the court system has, and it's an advantage that has been used. I think somebody is trying to do some home improvement in the background there, right? Thank you. That's a huge advantage that the court system has over arbitration, and it's one that's used in a number of different jurisdictions. There are jurisdictions that have specific settlement judges who deal with mediation. There are systems for early neutral evaluation within the court system, where a judge other than the judge hearing the case may give his or her impression of the legal merits to guide the parties as to what the real issues are or help them towards settlement. And now within the English system, which has developed beyond the stage it was at when we drafted the RDC, the English courts assist parties in identifying suitable neutrals that they can go to for a specific dispute. And so I did notice a question, for example, popping up just a moment ago on the question box about courts appointing ad hoc specialist judges. What courts can do is direct people to ad hoc specialist mediators in relation to their disputes. So the courts have this great freedom that arbitral tribunals just don't have because of the limits on their mandate, and courts should use that. Just finally, just picking up on Robert's point about the development of the law, and indeed Singapore. It's very interesting that the Law Commission of Singapore is now suggesting that arbitral agreements can include an optional provision allowing the parties to appeal on a point of law to the court, recognizing that the court is the place that makes decisions of law. And it sort of squares the circle that Robert was talking about, that you have the benefit of arbitration, but on the other hand, you also have the benefit of a decision of the state legal system on a particular point of law on that legal system. And I think that's a development that we're going to see in a number of different jurisdictions. Singapore tends to lead the way in terms of arbitral practice.
So on that point, Michael, as far as arbitration is concerned, when it comes to, let's say, court systems for ratification, recognition, or any dispute relating to that specific arbitration, do you think like court systems around the world should convert the actual arbitration case into a public matter, or having it, continue in confidentiality, within the confidentiality that it had already within arbitration, and maybe just publishing anonymous, let's say, judgments that are important for the legal community and as a point of law? What would you say in terms of courts' interaction, or let's say, handling arbitration-related cases when they come to the court system?
Yeah, I mean, that's an extremely interesting question, and it's one that has occupied certainly the English courts, and there are a number of English decisions on it. And it's also interesting that the ICC now says that it's going to publish the awards of arbitral tribunals suitably anonymized, so that there is a clear recognition that the arbitral community, parties who arbitrate, would benefit from seeing awards and seeing judgments based upon those awards. I think in terms of whether a particular court system anonymizes or not, it is very much in the hands of the parties in its discussion with sometimes the parties don't mind, and we've seen this in England, that we see non-anonymized decisions. On the other hand, other parties wish that their commercial relationships do have a degree of anonymity. So I think the court should have the opportunity to do both, and it should discuss with the parties whether they wish it to be. It's quite a bit of work for the advocates and indeed for the judge often in anonymizing a decision. It probably should be the default position because arbitration is confidential, and of course the DIFC arbitration law is one of the few laws in the world actually which provides for confidentiality of arbitral proceedings. In the English system, it's dealt with by common law. So it's a matter, I think, for dialogue between the court and the parties.
Robert, yes. Please.
Yeah, no, I just wanted to add, I mean, I think we have to recognize, at least as systems are currently set up, the status of an arbitral award is always going to be slightly inferior to a court judgment, it seems to me. Because, for example, taking the instance I referred to before about an arbitral award on set-off that Michael and I worked on, we could publish that award, but no one will know the arguments that went into that before the judges. No one will know, the procedure that we could agree that would only have 10 minutes argument, for example. And obviously we didn't appeal that, or the other side didn't appeal that to any other forum. That was just essentially a first instance decision by these three judges. So it would always be, even if we published it, a sense of that's a really interesting judgment, that's very helpful, but it's not binding, and we can't, we don't know how stress tested it was during that arbitration process. We can't be sure that the absolute quality of it, whereas obviously in the court system it's all done through the court system, so it's sort of validated as being the product of that system, however good that system is, but they can accept that. So I think they would need to do a bit of work to try and tie that up before we see a situation where an arbitral award is somehow binding or very persuasive. I mean, the ICC, as Michael correctly pointed out, is moving towards a system where they are publishing awards. I mean, they have in the past published awards, where they feel it's interesting, usually on procedural points, so people can kind of get an understanding of how certain difficult issues are dealt with by other tribunals. But again, it's never going to be binding on a new tribunal. And that's one of the good things about arbitration. The tribunals have a lot of power and aren't bound by precedents in the same way that the judges. So I think more work would need to go into it, but it would be great to have the best of both worlds, as Michael was pointing out there.
So from an in-house counsel perspective, when it comes to choosing the seat of arbitration, does the administrative court or supervisory court selection comes into play when it comes, helps in choosing the seat?
Absolutely. Absolutely, because obviously you don't expect, and more often than not, the local courts are not going to get involved in the arbitration. But if we have a jurisdiction where we know that if they did, it would be a high risk, for example, that we wouldn't be sure how they would deal with certain issues, or they would just take it over or whatever, then that's got to be a factor. I mean, we have, the way we operate as an organization, several seats which are preferred seats. You don't need to come to legal to agree that. These are the seats that we would push for. The IFC is one of those seats. London, places like this are obvious examples of these are good seats with good courts doing it. Now, often, we ask, well, why don't we use a certain country as a seat, which is a bit more exotic, for example, and we don't say no to that. We will look at that. We will consider it. If we consider it to be a high risk, then that's part of the risk factors that go to the business before they do the deal. It's very rare. I don't think I can think of a country which has absolutely off the table. There are some countries in the past that might have been off the table. I think almost all countries now at least purport to have a good functioning arbitration system with courts that would be supportive of it. I don't see too many which are like absolutely not. We don't want to hear about it. But in our footprint, we try to avoid those that we consider to be high risk, inconsistent, unnecessarily expensive or time consuming. These are things that we obviously want to avoid. And as Michael was saying, with arbitration, you're always going to come back at some point, most likely to a local court for enforcement, if not for some other aspect. So that is in the back of the mind, but these are just the factors to be considered.
Excellent. Michael, I would like to go back to the point, that you mentioned about larger claims and how we can consider perhaps, mediation options for those larger claims. And if we were to put a proposal what would that look like, in terms of maybe court systems starting to maybe provide fully fledged mediation services in-house for cases that, are within the courts that the judges believe, maybe like Part 27, they believe that they can be explored through mediation, or even generally speaking, do you think court systems should actually open maybe new venues for exploring mediation services or consultation, whatever we call it? Is that maybe a good way forward in terms of court systems handling mediation services as well?
I think so too. I certainly do agree with that. And the experience, particularly in the common law jurisdictions, obviously in the USA, which led the way, but in the UK, Australia, Singapore, Hong Kong have all shown that if the court actually takes the lead, and in some circumstances imposes sanctions on parties that do not mediate in terms of costs. Of course, the common law jurisdictions have the cost stick to wave at the parties that many civil law jurisdictions don't have, because of the absence of provision for large orders for party and party costs. So, for example, if a party is going to be sanctioned in costs for not pursuing mediation of a dispute or part of a dispute, in the very largest of disputes, it is possible, for example, for a court to say, look, quantum in this dispute is going to take up weeks and weeks of court time. Much easier if you sit down with specialist mediators, whether they be, engineers or people involved in a particular industry. That's going to be much more effective. Whereas there are some, important legal issues here that the court can decide quickly, and which will give guidance to the parties. So it's quite possible to have a hybrid of both court decision on issues of law and mediated settlements on the more commercial aspects of a case. And the important thing is for the court both to have flexibility and I think the power to at least steer the parties, if not compel the parties. Again, there's a great debate within the mediation community as to whether compulsory mediation is genuinely mediation, or whether the autonomy of the parties should be respected as to whether or not they wish to negotiate the settlements or just go before the court. But I do think, speaking of our own jurisdiction, the DISC, and wearing for a moment my hat as a member of the Rule Committee, that we ought to be considering perhaps updating our own rules to bring them a little more in line with other common law jurisdictions, where there are sanctions and where the courts are a bit more directive than I think we have historically been in the DISC in pointing parties towards mediation of the whole of disputes or parts of disputes.
Thank you so much, Michael. So Victor, I'm interested to hear from you. You mentioned in one of your answers, part of the research that you've taken care of was to look into robust mediation. So in terms of your own definition, what would robust mediation mean, and what are the characteristics of robust mediation?
Well, I think I mentioned online dispute resolution, which is more determinative. It's not so much mediation. I think mediation would be difficult to do by an online system. I mean, I don't mean virtual. Obviously, I've done virtual mediations where the parties are as we are here today, online as opposed to face-to-face. So that's possible. But I don't know that there's a mediation process that you could do online. That's more black and white dispute resolving, I think. I think what we're talking about here, when you talk about arbitration, I think in listening to Robert and Michael, I think one of the points is that arbitration has more room for expertise in the tribunal. That's I think it depends on the industry, I think, for arbitration. Obviously, we see a lot of construction arbitrations here, and that flows out of perhaps the FIDIC concept, where you have experts who are on the tribunal. It's not so much for, I can see that in general commercial matters, commercial judges obviously know what they're doing and they know the law. I think the advantage of arbitration, especially in this community, is that you have more expertise on the tribunal. Now, I hear what Robert's saying about you not setting the law. I mean, if you have a really good decision, you want it to be out there and for the public to understand. But really, what we get down to in arbitration is just resolving disputes for the parties efficiently and effectively. And I think arbitration still has the power to do that. Now, mediation is, of course, important. We still see a bit of a lack of uptake in the civil law jurisdictions, at least in the UAE. I mean, I've done some mediations. I've been proposed for some mediations, and sometimes they just founder because the parties can't really commit to it at a board level, at the highest level of governance of the party. They're not fully committed to the concept where they're going to have to give something up to get a resolution to their dispute. They'd rather fight hammer and tong, get some third party to decide it, and then they can just shrug their shoulders and say, well, that was obviously the dumb arbitrator who decided that, but we just have to move on. So I think there is still a bit more education to be done in certain markets as to the power of mediation. I think in the civil law system, arbitrators can act as mediators more readily. I know if you have German counsel before you, they're expecting you to mediate in some way the dispute prior to you launching into the arbitration part of the dispute. So it's still possible. I think we have to think of more robust ways to bolt mediation onto arbitration. I do think it's got some future. There's a bit more education to do. We have to get parties buy-in that that's what they want. As long as we get all those things, I think arbitration could be fairly useful in both certain industries as well as in mediated results.
On that point, Victor, like it's quite interesting because you mentioned the awareness or education of the parties that are involved. And that said, wouldn't it be in an ideal world that actually parties, as soon as, irrespective of what forum they choose, whether mediation or arbitration or court systems, that they actually reach that maturity that as soon as a judgment is, published or let's say issued, why wouldn't they just honor it and, get on with it, enforce it within their own, like rather than try and enforce it through, the complex available routes? Do you think that is something that maybe parties should, be more mature and maybe when they can actually do so?
Yeah, I don't think there's anything we can do about that. I mean, that's going to be the strategic decision of the judgment debtor or the award debtor as to what they are going to do. Sometimes they do pay. I mean, sometimes they negotiate at that stage and say, look, we can force you to a lot of enforcement proceedings. Maybe we'll take you can take some lesser amount, we'll pay you that, or we'll pay over time. I mean, that's maybe another form of post-judgment or post-award mediation that maybe we should look at. But, that's more a strategic decision of the parties, I think.
So Robert, I would, like to hear from you. So as Victor mentioned, like sometimes it's another negotiation as judgment, as judgment is issued. So what would you do as the judgment debtor, let's say?
Well, I mean, I think we all wish we lived in a world where people didn't break their contracts and people honored the orders against them and so on. Unfortunately, we didn't live in that world. I mean, it's quite interesting. Just give an example. In Dubai, I'm aware that quite often the enforcement judges will allow people to pay over periods of time, in what they consider to be reasonable. And that often means that when we are trying to enforce a judgment against a party, that we have to bear that in mind, that even if we say, fine, we'll just go through the enforcement courts, doesn't mean we're going to get paid one check, the full amount. By and large, the enforcement judge will probably allow them to pay over a period of a couple of years or whatever it is, at a certain rate and so on. And it's like, well, if we're going to end up there anyway, we might as well agree that now. And that's more efficient. So a lot of it is knowing your local court and knowing how the judge is likely to view it. And as I said, all these local courts that we work with across Africa and Middle East have all got slightly different approaches. Mediation certainly being one of the approaches that they try for the parties. In some jurisdictions, you have to do a mediation before you get to court. So it is a challenge. As Victor was saying, there's not an awful lot you can do about it. There are some parties that genuinely feel aggrieved by the award or the judgment against them and feel that it's not fair, and then they would rather fight it out. I mean, quite often, obviously, as Michael was saying at the beginning, as a bank, we're chasing people for money and they don't have the money to pay, or they're hiding it, or they've done something else with it, and we have to go through the enforcement mechanism to discover it and find it. And that's where courts like yourselves that have very robust mechanisms for finding out assets is tremendously useful. And if we're talking about other court systems, some are not as proactive or effective in that regard, and that again is a risk factor for the bank when we're looking at, well, where are the assets for this party? Are we going to be able to get them? As we know, in this part of the world, it's not easy to find out people's assets from local registries and so on. So these are all factors that come into play, and certainly we will try to avoid, in the interest of our shareholders, costly, expensive, lengthy litigation. And if that means having to bite the bullet and compromise, then that's to be considered. But equally, if we have to chase people down, that has to be done as well. It's whatever's best in the circumstances. I think one factor I was going to raise is people will be aware of the rise of third-party funding, and whilst that hasn't totally taken over our thinking process, it has been something effective for us in certain situations where we otherwise wouldn't be, limited litigation budgets, pushing every button that we have. But actually, if we're willing to, if a third party is willing to help fund that for part of the uplift afterwards, that can very much be a driver for pushing something which otherwise might not have gone as far as it did into a litigation process, so that we can eventually recover. So I think that's been one recent development that has been positive. But again, third-party funding is not right for every dispute in every situation. There's lots of variations to that, but it's certainly something that we've taken interest in, and we have and are using at the moment.
I'd just like to add something which is a feature of the DIFC court and indeed other similar courts along the theme of today's discussion of mediation and ADR, although not really strictly, I suppose, ADR. But we've been talking about award debtors and judgment debtors who won't pay. There are those who can't pay as well, of course. And the great advantage of the DIFC is, of course, that it has a sophisticated structure for the reconstruction of companies overseen by the court, which is only now being introduced across the region in other jurisdictions, is in its infancy. But again, court-supervised reconstruction of corporate groups, which we're seeing within this jurisdiction, is, if you like, a form of the court becoming involved in a reconciliation between a company and its creditors. And that's also something I think that we need to bear in mind. And it is a service that is offered by the DIFC court, and has been successfully in relation to some of the larger and more important insolvencies in the jurisdiction. Of course, the classic, of course, is the Dubai World Tribunal. I mean, essentially, the Dubai World Tribunal was an ADR procedure to deal with the restructuring of Dubai World. And so that's something the courts can do in relation to companies and their creditors once we're getting past the stage of the dispute and getting into the area of the enforcement of judgments and awards.
Thank you so much, Michael and Victor, for your inputs, and the same for Robert. Before we go into our last question, before we go into the Q&A, I just want to have maybe reflections from your experience with the pandemic in 2020. How do you think the different dispute resolution forums have dealt with the pandemic? What was your experiences really in private practice, arbitration, litigation? What would you say, like, your experience was and how the different forums reacted to such pandemic? And maybe in that specific period, were there specific forums maybe more able to get on with it in a way rather than others? So I'm keen to hear from you, all of you, really, regarding your experiences in 2020 and beyond, maybe.
Well, I can say from an arbitration point of view, it's moved ahead light years instantly. How we deal with virtual arbitrations. I mean, as a lot of us were, we were kind of skeptical on giving up the face-to-face arbitration, but the online ones that I've been involved in, especially if you have companies handling the documents and putting them forward for the witnesses, and you have good online support, they're brilliant. They work very well. I've had ones where people, I mean, the only thing, of course, is the time zone issue. You've got somebody in China and somebody in New York or somewhere, and the time zones are just not that cheerful for some people. Somebody's got to bite the bullet and get up at 2 a.m. to give their evidence. But other than that, it's worked brilliantly. We've had translators, we've had witnesses in one place, a translator in another place, us in different places, and it's worked very well. So I've been very pleased how we've adapted, certainly in arbitration, to the online environment. I've been involved in a couple of court cases, which it seemed like that was a bit rocky in the local courts, but I think generally people have adapted very, very well, and I think we've understood that we don't need to be in the same room to conduct a really good proceeding. So I think we moved ahead quite a bit.
I agree with Victor, but of course it's all about resources. I've had sort of variable experiences where we've had arbitrations very, very high value with very sophisticated parties. And it's been astonishing. Everybody's using 3 or 4 different screens, and we have the transcript scrolling in front of us as the evidence is given. It's being interpreted simultaneously. All the documents magically pop up on one screen, and you see everybody in high definition. However, at the other end of the scale, if I may talk, even in the English court system, my poor wife sits in the family courts, dealing with individuals, and courts all over the world are under-resourced, as I'm sure Amna will agree, and particularly, I suspect, in the family field, and she's had sort of nightmare experiences, frankly, with virtual hearings where people are sitting in their cars trying to talk on their telephone and give evidence in child custody cases, and so on. So it very much does depend, but at the highest level and the best resourced level, it's been wonderful.
No, I agree with that, and I did qualify my remarks somewhat by saying if you have the resources, I agree with Michael completely, that if you don't have the resources and if you don't have documents that are easily accessible online, and if they're not indexed and there's no way of getting to them, it can, well, I guess my late appearance also gives you some indication that not everything always works out. But so yeah, I mean, I agree with Michael. You should have the resources. You should do a proper job of it if you're going to do a virtual hearing.
And a very strong internet connection.
Yes, exactly.
Well, I was going to add, obviously I'm happy to hear that. I said most of the portfolio disputes that I have are in the local courts, and the vast majority across the region just stopped for COVID. I mean, they were just not open for business for a very long time, and when they have opened for business, a huge backlog. And there are some countries where in August we said, well, when is this going to be relisted? And they said, we're talking 2022. At some point in 2020, there's no way that certain cases are going to get on before then. A lot of them already had a backlog before COVID. So having the courts shut down, and then when they've opened, had to shut down again because there's been an understandable scare. It's been challenging. They have not had the kind of resources in terms of IT and so on that the DIFC courts enjoy, and they courts like DFC courts were already online to a great extent before that. When we talk about other national courts around the region, that's not been the case, and they've really struggled, from my perspective, to deal with getting these cases moved on. I mean, everything is just stopped So it's been challenging, and obviously when you're talking about ongoing litigation, it's not as simple as saying, well, it's all stopped, so we just pick it up again. Not only have you got to get back into the matter, witnesses have moved on, documents have moved on, things have moved on, and now we're hitting other procedural problems which we wouldn't have probably have hit if we hadn't have lost the best part of a year due to COVID. But that's all part of how it goes, unfortunately.
Thank you so much. So my last question as a wrap-up before we open the Q&A portion is really asking you the topic of today. Do you think that arbitration and mediation are the new way forward? And if so, are they loss of potential for international global courts? And I would like to hear from all of you. Michael, maybe you can start.
Well, I don't think arbitration is a new way forward, since I think the earliest the arbitration we know of occurred in Pharaoh's Egypt. So arbitration has been a long time around. What I think is the new way forward is the cooperation between the courts and arbitral institutions and institutions providing mediation. And I go back to where I started, the recognition that the court should offer a menu of options to parties depending upon the nature of the dispute, and to be proactive in doing that. I think that's where the way forward is. The courts should be directing parties and to be flexible and say certain parts of disputes it may be useful to hive that off to a specialist referee or a specialist ad hoc judge or a specialist mediator, and for the court perhaps to concentrate on the legal issue where precedent is important, and so on. So the way forward is flexibility and a menu of options offered to parties. That's what I'd say.
Thank you, Michael. Victor?
Yeah, I agree with that because what we see, especially in the international commercial court movement, if you can call it that, is that what courts have done is adopted some of the attributes of arbitration. So the parties have more power to choose things. They can choose the language. They can choose some procedural aspects. They get perhaps more technically minded judges off of a panel of technical judges that have technical expertise. So all of the flexibility that we find in arbitration, courts are trying to mirror, and that's a good thing. As I said before, the main thing is to get the enforcement piece done. Once you can enforce those judgments worldwide as you can under the New York Convention, then you'd be getting somewhere. I think that's the new way forward. If you look at Singapore, for example, the Singapore court we've mentioned before, it's a great court. It has the power to bind third parties, for example, but you couldn't enforce that judgment worldwide because some enforcing courts wouldn't recognize the power of that court to bind third parties who didn't consent to that. I mean, as we know in a lot of the rules of the commercial courts, third parties have to agree to be part of the proceeding. So things like this have to be ironed out. Otherwise, I think that is the way forward with robust mediation, as I said before. And I think courts are moving in that direction, certainly more quickly than arbitration, because we have the problem, as Michael indicated, when you have mediation and arbitration, an ARB-MED kind of process, or MED-ARB, it's difficult because then arbitrators have heard too much. How can they get their award enforced if they know some confidential information that the parties didn't want them to know? Had they known that it would have gone to arbitration, ultimately it gets very messy. So I think courts have the forefront in that. So the bottom line is to have a court with some of the attributes of arbitration with robust mediation bolted on the front end. I think that's the direction we're moving.
Exactly, like for example, like one main takeaway is like having court systems, as Michael mentioned, with multi-door courthouse concept and one-stop shop with a suite of services that can, be readily available for all sorts of disputes, all sorts of parties, all sorts of topics and, litigation and so forth. Very interesting.
More of a one-stop shop, exactly. That's right.
Excellent. Robert, any insights?
Well, I was going to say, I mean, you heard me talk about how all the local courts, in this part of the world pretty much stopped during COVID to a great extent. And you might think, does that mean we should, revisit the way that we do our dispute resolution and try and avoid that? Obviously, a weakness in the court system. A lot of them are just not flexible enough or prepared to deal with, these kind of issues when they come up, quite apart from other local issues that can arise. And the answer is no, we're not, that was an issue, but it is one of the factors that we have to consider. And it was great to hear what Michael and Victor were saying about arbitration, being able to sort of get on with it and adjust and keep going in a way that other systems like the courts were not readily able to do so. But no, I don't think we're going to suddenly shift all our disputes into arbitration mediation, because of the many benefits of court systems around the world. And it's as we were mentioning, it's great for clients and businesses to have a number of different ways to resolve disputes, because there is just so many different types of disputes, right? So that's what you want to see. And picking up what Victor said, it's great to see the courts responding to the developments in arbitration and vice versa, so that hopefully we're coming to a good real avenues that we can all use with confidence. And I think maybe we want to move away from any kind of process where everything just becomes the same, because we will just end up fighting against that. So I think my perspective is it's good to see how things are developing, and it's just about keeping in touch with all these developments. Obviously quite fast moving at times.
Excellent. Thank you so much. So if I may, we will move now to some of the questions that have been posed by our audience today. And feel free to take them all or individually. So one of the questions that we received was consolidation of arbitration centers. Why the change, and what hope does it bring? Michael, maybe you're aware about this topic.
Is that a question about Decree 34, I guess?
I guess might be.
Which is always going to come up. Let me say at the outset that I understand the idea behind Decree 34. This region has had a number of different arbitration centers. I think there is a lot to be said for having a single central arbitration center with a good set of rules and that parties can rely upon. So we await developments and we see how that is going to work. I don't think anybody can say more than that at the moment.
Thank you very much, Michael. Any comments on that? If not, then I'll move to yes, Victor.
Yeah, well, I was just going to say it'll be interesting to see what they do with the DIAC court, because that's an interesting development. It could lead to a much stronger arbitration center. But as Michael said, we have to wait and see what they do. I really hope that the members they appoint to the DIAC court are good arbitration, dispute resolution, mediation savvy people, and really understand the big job they have to take on, because it's going to be it's a pretty big job to take on the main arbitration center for Dubai and this region, because because the DIFC LCIA was working quite well. So that's big shoes to fill. So I think we do have to await developments, and we hope they're positive.
Yeah, the issue with that that Victor raises, and of course it's slightly off what we're discussing, and perhaps the last word on that point is in relation to the court of the new arbitration center. We have the problem with Article 10 of the Federal Arbitration Law, which means that no person who sits as an arbitrator in the jurisdiction can really sit on the court. So the court may not be comprised of people who are sitting arbitrators, but that's a debate for another day. So if I can leave it at that.
Thank you, Michael. Robert, any reflections?
Well, I mean, the DIFC LCAA was one of our preferred institutions. I was saying before we had preferred seats, sort of seats you didn't need to come to me to agree to. They were sort of pre-approved, and the DIFC LCAA, like the LCAA, like ICC, was sort of, you know, these are, you know, well-respected, you know, safe institutions to use, and we use the DIFC LCAA. And like I said, so when this came out, obviously it came as a bit of a surprise to us. And a bit of a challenge for the business, in the sense that, you know, the business don't like to see things which are unpredictable happening. You know, whether you should have predicted this or not, you know, leaving that aside. But I mean, we don't like change. You know, that's a risk factor. And, you know, as I can see from some of the comments, if you've agreed to DIFC LCA in your contract, or what are we going to do about that now? Now, I think thankfully, because of what's happened subsequently with some of the, you know, releases and information that's come through, and, you know, we can make some, you know, quick and easy changes to our agreements, and the parties can actually agree to not use DIAC and so on if they want to do. It gives enough flexibility that I'm not overly concerned with agreements with these clauses already in them. I think if disputes arise in a pre-existing DIFC-LCA agreement, you know, we'd be able to get through that without too many troubles. So it's not a massive concern. I think just from a business perspective, anything that comes as a bit of a surprise is not particularly welcome. You know, that's how life is generally. So there were concerns, you know, internally about, what does this mean for DIFC? What does this mean for arbitration? Blah, 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 blah. And we've had to deal with that. But I feel that, as Michael was saying, you know, I think people can appreciate where this is coming from. That, you know, we always have changes to systems. You know, once upon a time we didn't have DIFC, we didn't have all these things. And from the bank's perspective, we keep an eye on it and we adjust accordingly. Now, we can't use the DIFC anymore, fine, but we can still use the LCAA. We can also consider using DIAC once we understand a little bit more about how it's going to be restructured. And, you know, like any other institution, we take a view as to whether it's, you know, going to work for the kind of disputes that we have. So, you know, in some ways, we're sort of a neutral third party to what's happening, or so to speak, as to why it's happening, and we just sort of see what's now on offer and take a view as it comes.
There is one question, I'll read it, but we might need to maybe tweak it a bit. So to do with promoting arbitration / mediation in a specific jurisdiction, would it be ideal to allow court judges to act as arbitrators? If yes, is there a danger that a sitting judge will exert too much influence over the members of the tribunal? So what I mean, we've touched upon this slightly. So I think what the question is really more maybe towards mediation. So if it was an in-house court, or tell me, Michael, you know more than me.
No, I know this, and I don't know who put forward the question, but this is actually a point in a paper that I've put before the arbitration committee of the courts, chaired by Justice Shamlin. So under traditional English procedure, it was always possible to appoint a judge as your arbitrator. In fact, I have proposed that we amend the DIFC arbitration law to include that provision in the law itself, so that the parties have the opportunity, if they so wish, to nominate a judge as arbitrator, a sitting judge as arbitrator. It does demand a certain number of changes to meet the issues that are raised by the questioner very sensibly there. So first of all, it's only as a sole arbitrator, or as an umpire between two arbitrators, but we don't have umpire procedures very much in this jurisdiction. It tends to be, the umpire procedure tends to be confined to the shipping world, and really in London or Singapore a bit more. So the judge can only be a sole arbitrator. You can't have a judge being overruled by two non-judges. But also the appeal from the judge arbitrator is not to the court of first instance. You substitute the appeal or challenge procedures to the court of appeal. And this has been done in England traditionally. It's not done that much anymore because the Ministry of Justice say that judges are too busy and they shouldn't be sitting in private cases. But I have proposed that it be that we do look at, probably trying to introduce it here and to see whether it works, because I think it solves a problem which people tried to solve before. There was a suggestion in the past that you turn judgments into arbitral awards and use the New York Convention. As far as I'm aware, nobody's ever done that, and I've spoken publicly saying that I don't think it would work anyway, and it's against the dignity of the court to turn a public judgment into a private right. Whereas this way, the litigants get the benefit of having a judge, but also having a New York Convention award, because it is the judge is being an arbitrator. So I think that is the way that you get the benefit of the New York Convention, but also the benefit of the expertise of the judges of the court. So a very good question indeed.
Thank you, Michael, and thanks for whoever asked the question. Any further remarks, Michael, Victor, Robert, before we conclude the session today?
I was just going to say what Michael was saying is, it is a really interesting idea. It reminds me a little bit with the way we sometimes try and do mediation, which is go into the arbitration to a certain point where you've got all the pleadings, you've done all that cost, and then have the mediation. Obviously, you don't save so much, but at least you don't have to go through too much more expense. Maybe get a separate mediator rather than the existing arbitrator for other reasons, and then try and mediate it. If not, go back to the arbitration. So the ways that you can try and do it where it doesn't initially increase so much costs. I think as parties agreeing contracts, you want the low risk, tried and tested dispute resolution solution. So you would probably always go for your straightforward arbitration clause, your straightforward jurisdiction clause. But if those type of mechanisms become available and we start seeing people use them and they can be agreed to maybe afterwards and so on, then I think absolutely, anything that can help drive to a more sensible solution has got to be welcomed.
Excellent. Any final remark?
Well, I think generally, I think it's been discussed that in arbitration institutions, especially the ICC and some other ones, have been trying to lead the charge for, cheaper may be the wrong word, but less expensive, time effective, better arbitration proceedings. And I think there's a lot to be said for that. I mean, there is all the party autonomy issues. There's choosing the tribunal in various industries. There's the enforcement provisions. I think there's still a lot to be said from arbitration. But as we've said, if we can have international commercial courts that have the enforceability, the enforcement provisions that arbitration has, or even close to it, then I think there's a lot more power there. There's a lot more power to that type of dispute resolution mechanism, yes.
Thank you very much. With that, we conclude our first episode of Beyond the Scope series. I would like to once again thank our speakers for their time today and for everyone who was with us on the call or on the webinar. And I really thank you for such an engaging session. See you in our next episode and have a good day. Thank you, everyone.